This is potentially Lumacorp's most effective instrument for global control. Through international banking, we manipulate the fate of all countries. We've introduced many institutions, such as the IMF and WTO, that work in our favor to impoverish disobedient nations. Always remember, debt is a powerful weapon against countries that don't share Lumacorp's vision. Perhaps our greatest achievement in banking is the Federal Reserve System. It is a collection of international banks owned by Lumacorp members and financiers. It was created to form a centralized banking system through the Federal Reserve Act of 1913, an act that was indeed penned by some of our most esteemed members. Many of you might still assume that the government itself prints and issues the currency. That is not the case. When America needs money, they go to our boys and ask for it. The money is printed, but it is only representative of a loan. Interest accrues on that dollar until it is paid back to the Fed. In fact, the federal taxes paid by the American population go almost entirely to paying off this debt. So you see, Lumacorp derives a healthy amount of its operation funding directly from the debt of the public. Needless to say, this is one of our most crucial sources of funding and one of our proudest achievements here at Lumacorp. Through mergers and acquisitions, we have slowly and silently bought up the majority of U.S. industry. Lumacorp and its members own most of the oil, transport, banking, media, food and communications industries in America and abroad. Through fewer and fewer conglomerates, we are able to effect with great precision the machinations of labor and government.
This is why it's extremely important to understand what money is and where it comes from. In layman's terms, this is called fractional reserve banking. About 97% of the money in circulation isn't even real. 3% is notes and coins. So if you go get a mortgage or a loan, that's just numbers on a screen. They loan it out to you with interest. The interest is the only thing that is real. That's what you pay back. That's how they indebt everyone. This is why we're $324 trillion in debt. To who? It's to these people. It's to the Federal Reserve. It's to the elites, the Illuminati. This is how they've had a stranglehold on the entire world. Every single country that we were at war with, the purpose was to instill a centralized bank. This was the last president that tried to end the Federal Reserve. He had everything in place. And his last speech ever was, "We as a society are opposed to secret societies, to secret threats, to secret oaths." And here and behold, he was assassinated. Need to know the truth, and the truth will set you free. Peace and love.
You want to watch a movie?
All right, I'm about to show you guys.
Good evening. Welcome, everyone, to Burn the Corporate Fiction. Yeah, I figured I'd play somebody else's video to open up that time. That was pretty interesting. They say that's a Illuminati training video. Oh, look at that. I'm all stuck over in the corner. Stop speaking. Sorry about it. We're having a couple technical difficulties here. Shut up. Quit playing. Thank you. All right, let me get me back in the middle of the screen here real quick, shall we? And just by sharing that and then removing it. There we go. Much better. StreamYard better tighten up, dude. That shit's getting old. Every time I start the stream, I'm over in the corner. So you see we have AB Normal, Mojo. Here I am, Pat. Good to see Dirty Ketchup. Good to see you. Let's see, Sergeant Frog Dog, I see down there. If I didn't say already, good to have you, of course. And everybody else, good evening. So tonight I probably won't be streaming for too long, but I have a few things I wanted to show you guys. One of them was that video. I thought that was pretty interesting, but it ties right into, I highly doubt the Illuminati actually has a secret training video on YouTube. I mean, come on, right? Not going to happen. But everything that guy said in the video was 100% true. There is no real money in circulation. And so that dovetails right into perfectly another piece of information I want to show you guys tonight, the Credit River decision. I don't know if you've ever heard of that, but it's the Jerome Daly case where essentially the guy, Jerome Daly, he was a lawyer who was paying off his home was being foreclosed on when we got taken off the gold standard in the late 60s, right? And he realized that the bank was not actually giving him anything of their own out of their own account. So there was no lawful consideration coming from the bank. And so he ended up obviously getting the foreclosure stopped and he got his property back. But that judge and like half the jury who ruled on that case ended up being unalived. So that's interesting. We're going to take a look at that case. Got an awesome book we're going to take a brief look at that might explain why the small hats hate Europeans so much, people of European descent. Little bit of an interesting contention between two sources of law there. I'm going to show you guys that. And then, of course, I have the solution that I want to bring up to you guys. This is something we are working on in the Jurist Society, and it's called the Private Express Trust. And I just want to kind of go through and explain exactly what that is and why it works and how, like I had told Core Endurance, when Core Endurance had super chatted the other night, we were going to figure out a way to circumvent that pesky, being a foreigner coming over here and the only option you have is the 14th Amendment to naturalize under. That sucks, right? Well, you have no birthright to the states. This Private Express Trust is a perfect workaround to allow you to exercise all of the property rights that one of we the people would have at common law while not having to get deported. So there you go. All right. So first things first, let's take a look at this book. So this book is cool. It's called The Heart of Blackstone. And it is not written by Sir William Blackstone. That's why I had never seen it before. It's written in 1915, and it's more like a summary of, well, not a summary. It's more like a treatise on a treatise, if you will. And the reason I'm bringing it up to you guys today, I actually have to open it. So forgive me for not having it open. Bear with me for a second. It's right there. All right. So this is super cool. Written in 1915, right? And it starts out real strong right in the beginning. No questions of what common law is. So let me get back up to the top here. I was busy reading it earlier. It's an excellent, excellent book. We're going to skip past the preface and we're just going to go to the first part here. The source of common law. And look at this. For anybody who's ever had questions, for all the atheists who say God doesn't have anything to do with law, this is a well understood, well-known fact amongst jurists that the common law is grounded upon the general customs of the realm, and it includes in it the law of nature, the law of God, and the principles and maxims of the law. It is founded upon reason, and it is said to be the perfection of reason acquired by long study, observation, and experience, and refined by learned men in all ages. Okay? And that's absolutely true. And the law of this republic and the law of Canada and the law of England and the law of Australia are all common law for good reason. And they can never get rid of it. They can merely bar your access to it by locking you into a trust indenture, which is what the 14th Amendment is, where you become the mere usufruct of your own property, chattel property of your own estate, and you're stuck in a trustee position regarding all of your rights are derived from property. Every last bit of what you would consider your rights are derived from property. So your relationship to your property determines the law that you're under. And what they've done to the 14th Amendment citizen is they have reduced that entity. Well, that entity was already reduced in the first place as under the administration of the federal corporation, but they then mortgaged, because you were under the administration of the federal corporation, they were able to mortgage your estate to the central banking cartel, which then caused your property to be held in trust. That's why they created the Social Security Act, so that all of your registered property can be linked to that trust account, and they can create attachments to it in order to generate their own commercial paper, as well as control your behavior, obviously, because that's really what it's all about at the end of the day. The reason a central bank's necessary for communism to exist, for absolute feudalism to exist, is because you have to have a private third-party money system to indenture the citizenry to. You have to. And that's why Karl Marx said that a central bank is absolutely essential to communism, because you have to be able to bond the population to the debt of a foreign principal. That's it, point blank, period. So without going too much into that, which I did kind of, right? Yes, this book does, yeah. Afflees Gertra, sorry about that, man. That was a little tongue twister for a second. Afflees Gertra says that this book has some really cool stuff in there. Yes, it does. And one of the one of the things I noticed right off the bat was this. And no, he asked, have you heard of Melvin Stamper, author of The High Priest of Treason? No, but it sounds like a book I'd be interested in. I will look it up. What I picked out of this book right off the bat was something I had already known. If you guys caught one of my shorts recently, I detailed how, well as you can in 3 minutes, detailed how for the past over 1,000 years, there's been a war being waged between two systems of law, and the common law and the Roman civil law. The common law being the law of nature, nature's God, is applied to society, the rules and maxims of law, and the customs and usages of the people, right? The Roman civil law is the law of Caesar or the Pope, and it reduces everybody to property in a national trust and then governs them as if it's their parent and taxes them as if it's their parent. And that's Roman civil law. So these two systems of law have been at war with each other ever since William the Conqueror came over and conquered England. I haven't found in a treatise of law until this book where it actually details this and gives some more insight into perhaps why the small hats are trying to do everything they can to destroy the nations of European descent. So it says the world has been dominated by the genius of two great races for several thousand years, the Semites and the Aryans. The former, as nearly as scholars can discover, had its original home in the desert and barren peninsula of Arabia. From that land, which never afforded sufficient sustenance for the people born upon it, no shit, it's just a desert, the Semites wandered into the Mesopotamian valley and established a vast and powerful empire upon that of the Sumerian and Akkadian, right? Already strong and flourishing. So it says, in the course of the centuries, they also conquered the empire of Babylonia and Assyria, controlled Egypt, and occupied the numerous small states in Asia Minor. The Aryans came down from the northern Asia and settled in India. Yes, very few people know that Indians are actually considered Indo-Aryans, right? Kind of throws a whole wrench in the gears of that anti-Semitism thing, right? So, but now we see why that exists. Persia, Europe, and the islands of Great Britain. These races differed temperamentally. The Semites practiced polygamy and made the tribe the unit, the patriarchal system being their ideal. Well, let me translate that. Government is daddy, communal ownership of property controlled by the government, i.e. communism, i.e. feudalism, i.e. Roman civil law. That's absolutely true. So it says their religion was based upon the idea of one supreme being with public worship. Among the Aryans, the family was the unit, the young man was the hero, and individual rights were recognized, right? Their worship was conducted in the privacy of their own home. And so that's the big difference between these two. And the history of law has literally been the history of a battle between the Semitic law that ended up manifesting as either Talmudic or Roman civil law, which are pretty similar, and the common law, which respects personal rights, personal liberty, privacy, right? It exalts the family as the main political subdivision, not the whole tribe, right? And it is the foundation of Western law as it existed until the central bankers, on behalf of their Khazar overlords, came over and instituted Roman civil law, which I don't know if you guys had a chance to watch the short I did on the Khazars, but I'm surprised that's actually on YouTube. I'm gonna be honest with you. All right, so I just wanted to show you guys this. This is sweet. You can find this on archive.org. I actually found this through a link on, well, actually my dad sent me this link and I think he got it off X. So it's not hard to find. I recommend that everybody get this, read this, and we're going to move on. So next up, we have what I like to call the Credit River decision. Now, this is a very difficult case to find for good reason. If you even look up the Credit River decision, it's not going to tell you what actually happened, because this is a big ass black eye for the central banking cartel. Let me tell you something. So I don't know if any of you had ever heard of it, but I know that when my dad was on my show the other night, he had pulled up a clip of the Credit River decision. Somebody actually made a short out of it. So I figured, hey, why not go through the actual case, right? All right. So the above entitled action came before the court on January 22nd, 1969. So this is right after the Bretton Woods Agreement, or right after Nixon took us off the gold standard, and we made a treaty with OPEC to back the Federal Reserve note internationally with oil from the Organization of petroleum exporting countries. Now, this is important because even though they mortgaged our estates in 1933 and to secure the issuance of debt securities, Federal Reserve notes, they still had to settle their international debts with gold. So I'll show you that real quick. We might as well. So right here, it's telling you if the Republican Party, it's up here, this is March 9th, 1933, page 83, House Congressional Record. The Republican Party had released itself from the clutches of Wall Street and expanded the currency immediately after the stock market crash in 1929, or within a year after the crash. Our people would have been saved from this awful money panic. Our president will doubtless ask amendments to this new law when the conditions are more normal and when it's better understood, which they didn't. No, they didn't. Under the new law, the money is issued to the banks in return for government obligations. Well, it's actually your obligations because you are what was mortgaged. Now your property is held in trust as collateral for this public debt, and they admit it right here. So obligation, bills of exchange, bank notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. So they mortgaged you. They mortgaged your property rights, okay? But they could only do that to the 14th Amendment citizen who's actually under federal congressional jurisdiction. The very nature of the 14th Amendment in the first place, as I talk about all the time, is a trustee under administration. Immediately by becoming a 14th Amendment citizen and accepting privileges, immunities, benefits, and protections from the federal corporation, they tell you right in the 14th Amendment that you're not allowed to question the public debt, which tells you that you have just come under administration and they plan to use you as capital stock. Now, the way that they're able to do that and why they put the fourth provision is because by operation of law, when somebody becomes dependent on somebody else for specific things, especially the 14th Amendment is like actually a creature of the federal corporation. So it owes its entire existence to the federal corporation. Then you necessarily must take on the will of that on which you depend. So that's just how it works. And they were able to use that administrative capacity to mortgage the estates of all the 14th Amendment citizens, 1933. So that was good for, and it tells you right here, no gold coverage. The money so issued will not have 1 penny of gold coverage behind it because it's not really needed. We do not need gold to back our internal currency. We only need gold to settle our balances with foreign countries. Now that'll bring us to Jerome Daly over here. Okay. So when this case took place, this was when they decided they had expanded the security scheme to other countries sufficiently enough and indebted all the third world nations to the World Bank with their economic hitmen. They had decided that they don't need to settle their international debts with gold, that they can come up with an alternative because they wanted to take all the gold, obviously, right? Well, they didn't even have the gold at this point. Let's be honest. They don't have it today. Definitely not. It's like under the Rothschild's mansion or something. Maybe it's on Little St. James Island. We don't know. But it's definitely not Fort Knox. That's for damn sure. So, and whatever happened to auditing that, by the way, right? What happened with that? Anyways, so this lawyer, Jerome Daly, was upside down on his house and they were foreclosing it. And he realized that because we're not on the gold standard anymore, the banks aren't actually loaning anything out of their own accounts. They're not loaning anything, right? They're basically just shifting a balance on a ledger sheet from debt to credit or from credit to debt, right? So that's it. That's all they're doing. It's double entry bookkeeping. It's credit on their side of the ledger. It's debt on your side of the ledger, and none of it actually exists, right? And it's your signature that creates the value because it's your obligation, your promise to labor, just like the Federal Reserve notes. And so he took this to court, and we're going to read. He won. And after he won, this judge and about half the jury got killed. So just be aware of that. Now, Alfiz Gutra says, it bothers me when the adjective race is used where I suspect it would be appropriate to use the term ethnicity as we're all among the human race. Well, I don't even like the word human. I say we're all mankind. That's how I look at it, right? But we're not the ones who choose to differentiate ourselves. The ones who call themselves Semites are. They're the ones who want to be separate and are special and above everybody. It's not me saying that's them. They're the ones, yeah, you're Goy and we're better than you. So, and we're going to enslave you. And if you don't want to be a slave to us, then we're going to punish you. You know what I mean? So yes, as far as everyone else is concerned, if we could all just realize who's actually screwing us over, and it's not even a race or an ethnicity, it's the wealthy people. It's the same people who owned slaves during the Civil War, right? It's the same people who own slaves. It's the same people who own the slave ships. It's the wealthy. It's not that it has nothing to do with races. Okay. Nothing to do with races. So you're right in saying that. But anyways, back to this. Jerome Daly, I'm pretty sure, is a black guy, by the way. So it says an action for the recovery of real property was brought before this court for trial on December 7th, 1968 at 10 a.m. by jury. A true and correct copy of the judgment decree entered in this court on December 9th, 1968 is attached as pages 14 through 17. On January 6, 1969, this court filed a notice of refusal to allow appeals with the clerk of district court, right? So he says Minnesota statutes annotated 532.38 required that the appellant, First National Bank of Montgomery, deposit with the circuit or the clerk of the district court within 10 days $2 of lawful money of the United States for payment to the justice for all whatever the hell that is. Oh, justice of the peace before whom the cause was tried. This was one of the conditions for the allowance of an appeal. 2 $1 Federal Reserve notes were deposited with the clerk of the district court. One was issued by the Federal Reserve Bank of San Francisco, bearing the serial number, and then it says the serial number. And the other one, or the other on deposit, was issued by the Federal Reserve Bank of Minneapolis, bearing a serial number of that. A specimen for illustrative purposes is as follows, and it shows you right here. So says the court determined that said notes on their face were contrary to Article 1, Section 10 of the Constitution of the United States, which demands that gold and silver be used as legal tender in the payment of debts. And also, based upon the evidence deduced at the hearing on December 7th, 1968, the notes were without any lawful consideration and therefore were void. However, this court indicated that it would give the plaintiff, First National Bank of Montgomery, a full and complete hearing with reference to this issue. And so, long story short, without boring you guys to death, it says the findings of fact, conclusion of law. It says that the Federal Reserve Banking Corporation is a United States corporation with 12 banks throughout the United States, including New York, Minneapolis, and San Francisco. That the First Bank of Montgomery is also a United States corporation, incorporated and existing under the laws of the United States, and is a member of the Federal Reserve System, and more specifically, the Federal Reserve Bank of Minneapolis. That because of the interlocking activities, transactions, and practices, the Federal Reserve banks and the national banks are, for all practical purposes in the law, one and the same bank. It's all one bank. It's all just one bank. As is evidence from the book, The Federal Reserve System, its purposes and functions, put out by the Board of Governors of the Federal Reserve System, Washington, D.C., 1963, and from the other evidence adduced herein, the said Federal Reserve banks and national banks create money and credit upon their books and exercise the ultimate prerogative of expanding and reducing the supply of money or credit in the United States. That's a wild accusation, but it's true. The creation of this money or credit constitutes the creation of fiat money upon the books of these banks. When the Federal Reserve banks and national banks acquire United States bonds and securities, state bonds and securities, state subdivision bonds and securities, mortgages on private real property and mortgages on private personal property, wonder what that is. That would be the mortgage of your estate. The said banks create the money and credit upon their books by bookkeeping entry. The first time that the money comes into existence is when they create it on their bank books by bookkeeping entry. The banks created out of nothing. No substantial fund of gold or silver is back of it, or any fund of it all, right? So the mechanics followed in the acquisition of United States bonds are as follows. The Federal Reserve Bank places its name on the United States bond and goes to its banking books and credits the United States government for an equal amount of the face value of the bonds. The money or credit first comes into existence when they create it on the books of the bank. So they're not giving you anything. So the law of contracts stipulates that there must be equal consideration in order for a contract to be valid. That means I have to give you something of mine. You have to give me something of yours. And there has to be a meeting of the minds. There has to be equal consideration. If there is not, then the contract's void. And that's how this guy beat his foreclosure. And if you're just tuning in, it's called the Jerome Daly or the Credit River decision, the Jerome Daly case. And good to see you do it. Good to see you. We got the fallen slave us all. Yes, that is true. Why would anyone unalive those people? Yeah, probably because this judge, who was a member of the bar, undoubtedly, ruled against the very scheme that they've spent so long setting up. So they had to make him pay, is what I would guess. But hey, maybe it was all just coincidental accident, and just half the jury and the judge just coincidentally passed away after adjudicating one of the most damaging cases to the Federal Reserve System in modern history. Just sort of like Louis T. McFadden ended up dying shortly after filing impeachment charges against the Federal Reserve Board of Governors and the Department of Treasury, but I'm sure that was a coincidence too. So the Federal Reserve Bank of Minneapolis obtains Federal Reserve notes in denominations of $1, $5, 10, 20, 50, 100, 500, 1,000, 10,000, etc., for the cost of printing each note, which is less than 1 cent. Wow. The Federal Reserve must deposit with the Treasury of the United States a like amount of bonds for the notes it receives. The bonds are without lawful consideration, as the Federal Reserve Bank created money and credit upon the books, by which they acquired the bond. So we'll skip down here to the conclusion that the original judgment entered in here on December 9th, 1968 is in all respects confirmed. This is the appeal, by the way. They had already ruled on this December 9th, 1968. So the Federal Reserve notes on deposit with the clerk of the court are not lawful money of the United States and in violation of the Constitution, right? So Article 1, Section 10 of the Constitution provides that no state shall make anything but gold or silver legal tender in the payment of debts. The act of the clerk of the district court is the act of the state. The clerk of the district court is the agent of the judicial branch of government of the state of Minnesota. Now, this was from a district court in Minnesota. All right. Well, here's the thing. It doesn't matter what value the bond held, because there is no money involved. There's no actual money involved. That's the thing. And they were just using the bond as an example. Like, this is how the Federal Reserve is able to put money in circulation, is they take a government bond and then they issue notes in the value of that bond, but not one single time are they actually putting any of their own money into the system, right? Which would be required for a valid contract. So, and the reason being is, so there's, like they said earlier in the case, that they look at the Federal Reserve Bank of Montgomery and the Federal Reserve to all be one bank. Like, so all of the all the banks in the country, the United States corporations that are banks, and the Federal Reserve are actually all just the Federal Reserve. And it's all a privately owned and controlled banking system. And that's what they're saying. And this private banking system, when entering into contracts with the people of this republic, are not actually giving anything of their own. So when they enter this mortgage contract, say with like Jerome Daly, and he puts up the land that he's purchasing or that he's buying as his consideration, he's putting up his house and his land as consideration for the mortgage, right? Well, the federal or the bank has to also give up something of their own, right, as consideration for that to be a valid contract. This is a fundamental principle of contract law. And the fact that they do not renders all contracts in this country null and void. That's very important to know. So I have this other Credit River document I'm not really going to go into. I'm just going to run over it because the whole point of tonight is actually the Private Express Trust. And that's what I'm going to get into here in just a second. But let me see what this other Credit River. There it is. All right, let me pull this over here. All right, so this just tells you the synopsis here. Let me get back so I can see your guys' comments, right? I know it's a bit tough to see, small print. I'm going to zoom in for you. There, that should help, right? All right, yes, it is debt paper. Aflis Gertra. Man, I hope I'm saying your name right. It is all debt paper. Yeah, it's all debt securities. And so the Supreme Court has upheld many times, rightfully so, that a promise to pay does not constitute payment. That a promissory note or any other kind of debt security only becomes valuable upon the performance of the obligation set forth in the note or in the commercial paper. And so it isn't actually anything of inherent value until that takes place, and therefore it cannot be used as lawful money. And this has been upheld a multitude of times. I actually need to gather those cases together. I'm sure I have a favorites folder with all those cases in there where the Supreme Court says that. Also says like Planners Bank versus United States, or the United States versus Planners Bank, is that when the government engages in trading enterprise with a private trading company or association, that it divests itself of, and it actually says the word divest, which is not actually, but apparently it was once upon a time where it says divests itself of sovereignty and takes on the status of a mere private citizen. And so right now the United States, and that's what's infuriating about them indenturing us and mortgaging our property, is because they're in a commercial enterprise with private international banks, they have no sovereign capacity. It's no different than just like some other dude basically using you as collateral for his debt. It's literally what it is. Some foreign dude using you as collateral for his debt. There's no difference. So on May 8, 1964, the writer executed a note and mortgaged the First National Bank of Montgomery, Minnesota, which is a member of the Federal Reserve Bank of Minneapolis. Both banks are privately owned and are part of the Federal Reserve banking system. In the spring of 1967, the writer was in arrears, $476 in the payments on his note and mortgage. The note was secured by a mortgage on real property in Spring Lake Township in Scott County, Minnesota. The bank foreclosed by advertisement and bought the property in at a sheriff's sale held on June 26, 1967. The writer made no further payments until after June 26, 1967, and did not redeem within the 12-month period of the time allotted by law after the sheriff's sale. So the bank brought an action to recover the possession to the property in the Justice of the Peace Court at Savage, Minnesota. The first two justices were disqualified by affidavit of prejudice, the first by the writer and the second by the bank. A third one refused to handle the case. It was then sent pursuant to law to Martin V. Mahoney, Justice of the Peace, Credit River Township. So this was at common law even. And this is why they want to bar your access to common law, because you need to be able to go to common law to challenge the validity of the trust indenture in the first place. And without going to a court of common law to do that, the courts of equity are only ever gonna want to hear about the trust arrangement. They don't want to hear, or they're not going to entertain a challenge to it, because that would challenge the court's jurisdiction, the validity in itself. So what you have to do is show up by special appearance every single time, send them a notice of special appearance prior to showing up, and then show up by special appearance and challenge that jurisdiction. You presume me to be a trustee and infant chattel property of my own estate, right? And the state's not under administration, it's been claimed. But the private express trust actually cures a lot of that issue, because, and I'll explain once I get to that here in just a few minutes. But all right, so it says Scott County, Minnesota, presided at a jury trial on December 7th, 1968. The jury found the note and mortgage to be void for failure of lawful consideration and refused to give any validity to the sheriff's sale. Verdict was for the writer, with costs in the amount of $75. The president of the bank admitted that the bank created money and credit upon its own books, which it acquired or gave as consideration for the note, and that this was the standard banking practice, that the credit first came into existence when they created it, that he knew of no United States statutes which gave them the right to do this. This is universal practice of these banks. The justice who heard the case handed down the opinion attached and included herein. So let's go down to the opinion. Is this by? Okay, so that's a memorandum. This is the judgment. And then the memorandum says the issues in this case, I know you guys probably can't see this very well, but I'm just going to read this real quick. I'll try to zoom in a little bit more though for you. The issues in this case were simple, that there was no material dispute on the facts for the jury to resolve. plaintiff admitted that in combination with the Federal Reserve Bank of Minneapolis, which are for all practical purposes because of their interlocking activity and practices, and both being banking institutions incorporated under the laws of the United States, are in law to be treated as one and the same bank. So understand that all of JP Morgan Chase, First National Bank, Bank of America, all these different banks are actually just one bank. It's just the Federal Reserve. That's all you're ever dealing with, right? All your credit card companies, all your insurance companies, all of these companies are actually just the Federal Reserve. At law, they're to be treated as one and the same entity. It's funny, I got a little this. Athlete says, if you mention the Constitution again, I'll hold you in contempt. Yeah, and the Constitution, if you go in under general appearance and you're there arguing with them in their court of equity as a 14th Amendment citizen, nothing in the Constitution applies to you except the 14th Amendment. That's why I call the 14th Amendment the 14th Amendment contractual black hole, because it is the one contract that you enter that places you under Congress's unlimited ability to force you to contract or to contract on your behalf, which they do quite liberally, actually. So, absolutely. All right, so it says they're all one in the same bank, and it says that it did create the entire $14,000 in money or credit upon its own books by bookkeeping entry. This was the consideration. Consideration is what each party gives and what each party receives as a result of a contract to make the contract valid. So if you buy a car from me for 20, silver dollars, right? You buy a car from me, then my consideration that I give you, or your consideration is the car, my consideration is the 20 pieces of silver. And if you don't give me the 20 pieces of silver, but take the car anyway, then the contract's null and void and you just stole from me. Well, that's essentially what's going on here with these Federal Reserve banking systems, is that they're not giving you anything. They're just writing numbers down on now they type it in, just typing numbers down on a ledger sheet and then charging you interest for them literally doing nothing and giving nothing of their own. And so that's why they said was the consideration used to support the note dated May 8, 1964, and the mortgage of the same date. The money and credit first came into existence when they created it. Mr. Morgan admitted that no United States law or statute existed which gave him the right to do this. A lawful consideration must exist and be tendered to support the note, period. The jury found that there was no lawful consideration, and I agree. Only God, check this out again, because this goes back to common law. This is a court of common law, the superior court that he won at. Only God can create something of value out of nothing. And that ultimately emphasizes the point I make all the time, that this Roman civil law trust indenture system is literally trying to usurp God's authority. They think that they can make laws to regulate mankind's behavior, and they think they can just create something of value out of nothing. And neither of those things are true. But those are the two linchpins to the entire system. And it's essentially trying to play God. There's no other way to put it. There's no other way to look at it, in my opinion. So, all right. Now, with that being said, I'm going to show you guys a video real quick. It's my video. I'm sure some of you have already seen it, but it's going to lead us right into this topic of private express trusts. So this is what we are doing in the Jurist Society, and it's incredibly. I can't take credit for the idea, right? Obviously, private express trusts have been around for a long time, and it's actually how the wealthy people protect their property still to this day, to keep it from the all-seeing creature that they created, the corporate state. But it is amazingly clever, not only is there a plethora of Supreme Court cases to support the private nature of the private express trust and not being subject to public policy, it's protected by the Constitution, Article 1, Section 10, that says no state shall make any law impairing the obligation of contracts. And the way that we are drafting the trust instrument in the Jurist Society is exceptionally clever. Now, it can be construed as trying to circumvent public policy, which would technically be unequitable. But the truth is that it's actually maintaining concordance with the law of the land and the Constitution of the United States, just like in this Credit River decision, right? And so what we put in our trust, well, let's watch the video and then I'll explain it. Where's my cursor? There it is.
Most people don't realize it, but since 1933, your life and property have been pulled into a hidden commercial system. Your home, your labor, even your car has been pledged as collateral for a debt you never agreed to. But there exists a lawful remedy, a private express trust. And when properly declared, it can shield your property from being forced into commerce. In 1933, under emergency powers, the U.S. effectively mortgaged the property of the people to sustain the Federal Reserve System. Your birth certificate became a financial instrument, held in trust as a bond. From then on, everything you acquired, land to wages, automobiles, was assumed to be held within this public commercial system. Registration, licensing, and taxation became the tools of enforcement. When you register a car or apply for a driver's license, you're not just filing paperwork. You're voluntarily placing private property into commerce, pledging it as security for the public debt. Courts and police enforce this presumption, turning you from an owner into trustee of someone else's estate. Equity courts thrive on this arrangement, treating you not as a freeholder under common law, but as a trustee bound by obligations. Fines, fees, and tickets are the revenue streams, commercial paper created from your consent. But there is a lawful escape. A private express trust is not part of the commercial system. It is a contract, a declaration of intent between grantor, trustee, and beneficiary that operates under common law. Unlike public trusts regulated under statutes such as the 1939 Trust Indenture Act, a properly drafted private express trust remains outside their reach. For example, you place your automobile into a private express trust. The trust instrument clearly states, the property of the trust is never to be used for commercial purposes under any circumstances whatsoever. That clause creates a binding obligation. Under Article 1, Section 10 of the U.S. Constitution, no state may pass a law impairing the obligation of contracts. Therefore, if a police officer compels you to register the vehicle or a court demands a license, they would be forcing commercial use in direct violation of your trust contract, and by extension, the Constitution itself. This is not a loophole, it's law. A private trust severs your property from the commercial net. It declares, this asset exists in the private, not the public. And once declared, no statute may override that obligation. Of course, the system resists. Officers on the roadside, judges in equity courts, will insist that statutes apply to everyone. But here lies the power of the trust. You can lawfully challenge their jurisdiction. By presenting the trust instrument, you assert that the property is already bound by contract, protected under constitutional law. If pressed, the matter escalates into a question of contract impairment, a constitutional breach. The Supreme Court itself, in Erie Railroad v. Tompkins, 1938, reaffirmed that courts must honor private contracts under state common law. A private express trust returns assets to the private realm, beyond the commercial debt web that has entangled us since 1933. Technology may tighten their grip with digital tracking and AI surveillance, but awareness, action, and private contracts remain lawful shields. The system only binds you if you consent. Withdraw consent. Declare your property private. Let the trust do what it was always meant to do. Protect the estate for the benefit of the living, not the creditors of the dead. Learn how to claim your estate and transfer your assets into a private express trust by searching Burn the Corporate Fiction on YouTube, Rumble, Facebook, X.
All right. Yeah. So a little bit longer short than my ordinary ones, but private express trust is the answer, especially for those of you who are foreigners who have come here and been forced. Obviously, there are no state naturalization courts, which ordinarily under our original republic were district courts that proceed according to the course of the common law and are courts of record. That's what they had to be able to confer citizenship. Okay, that's ex parte. I've actually got that for you guys. because, I always bring the receipts. I don't just talk out of my ass. So here, why not show you? It's ex parte, what the hell is it called? Knowles, this one. Ex parte, which means single party motion, right? It says the power to naturalize is made a judicial power by act of Congress. Congress cannot confer any judicial power upon a state court. The provision of the Constitution of the United States, which gives Congress the power to establish a uniform rule of naturalization, is construed to mean that when the rule is established, it shall be executed by the states, right? So Congress is not supposed to be able to confer citizenship whatsoever. The 14th Amendment is such a sham. It is the Jenga piece. You pull it out, whole thing collapses, okay? Under the Act of Congress of 1802, every court of record in any individual state having common law jurisdiction and a seal and a clerk or protonotary shall be considered a district court within the meaning of this act. And such courts have the power to naturalize. So it has to be a common law jurisdiction. It has to have a seal, has to have a clerk or protonotary, and it has to be a court of record. Now, this tells you that all courts, this is why I keep this up, the ex parte Knowles, and here, if you guys want this as a reference or resource to use for any retarded bar pirate that you might be dealing with, here you go. Good to see you, Kevin. Glad you made it. So anyways, this tells you right here, without question, okay, that any court that is not proceeding according to the course of common law and keeps a record is considered an inferior court. I'll show you. It says all other courts of this state being courts of inferior and limited powers, and although some are courts of record, yet having only statutory and not common law jurisdiction, they have no power to grant naturalization. So that tells you two things, right? One, the most important thing is that it requires a common law court to confer citizenship. The second thing is that any court that does not proceed according to the course of common law is an inferior court. Okay. So the reason I'm bringing this up is if you're a foreigner and you just moved here and you moved here, they've barred access to this with the National Trust Indenture, the Emergency Banking Relief Act, and all that stuff, right? They can never get rid of common law. You can still use common law against them because the power that they have to hold court was borrowed from us in the first place. We vested them with a portion of our sovereignty to hold court, but we never divested ourselves expressly. Okay, so it doesn't say, and the Magna Carta even says no free man shall be deprived of his court, but that's not what I'm getting into tonight. What I'm getting into here is the only option somebody from another country had was to naturalize under the 14th Amendment, which is bullshit, because then you're immediately collateral for the public debt and you're placed in a trust indenture and you have no property rights and all that good stuff that comes with being a good old U.S. public chattel, right? So the private express trust, what it is a common law contract, all right? So for us to fully understand the gravity of why it works, we have to look at what our common law property rights actually are. And we're going to pop over here. All lands within the state are declared to be allodial and feudal tenures are prohibited. So this is Article 1, Section 14 of the Wisconsin State Constitution of 1848. Article 1, Section 14 tells you all lands are allodial. Now, for the gravity of what that actually means, I'm going to go over here to this dictionary, okay? And we're going to go to legal dictionary. Well, not yet. We're going to go allodial. All right, legal dictionary. Free, not subject to the rights of any lord or superior, owed without obligation of vassalage or fealty, the opposite of feudal. A description given to the outright ownership of land that did not impose upon its owner the performance of feudal duties. Well, guess what? If you own a house now, you don't own it, and you are subject to the performance of feudal duties. You have to keep your yard a certain way. You can't have certain things up in your yard. You have to pay property taxes every single year. Otherwise, if you don't pay that property tax, what happens? The Lord comes and takes it back and then resells it. So you never own it. It's feudal. How did we get there? When it clearly states that the lands within the republic, because of the doctrine of parity, the doctrine of equal footing, essentially that all states enter into on the same footing as the original 13 states, that means Wisconsin's lands being allodial, everyone's lands are allodial, right? Secondly, the county putting in tax assessment and charging you property tax every year is a form of feudal tenure. Not to mention that, but all the ordinances and the regulation of your property telling you, if you want to go build a deck on the back of your house, can you just go build a deck? No, you got to go get a permit from the city or the township or wherever you live. And then you've got to have it inspected, all this English law bullshit that's actually Roman civil law, okay, that has no place in this country and is foreign. Okay, so this is important. We're going to get to the private express trust, but you have to understand what our property rights are. So allodial. Now let's look at feudal. Tenure. Let's see if it actually pulls up feudal tenure. If it's just, no. All right, so you just have to do feudal. Whatever. And what's cool about this dictionary, and I say it all the time, is it gives you not just one definition, but a bunch of different law dictionary. You can go thesaurus dictionary, medical dictionary, financial dictionary, legal dictionary. And that's what we do. We do the legal dictionary. So a series of contractual relationships between the upper classes designed to maintain control over land. That sounds like exactly what we have going on here, right? So this is going to be probably Bouvier's dictionary. And look, of course, it all goes back to 1066. William the Conqueror brought feudal framework to England, right? And how did he do that? He had the lords, or they weren't lords at that time, the nobles, who had a allodial title. And this is Blackstone. I'll tell you read Blackstone's commentaries. And he tells you that the nobles had a allodial title. But William the Conqueror, after he conquered, he allowed Denmark to come in and invade. And after he had removed England's military law, and after Denmark was done with their occupation, he came back and was like, hey, you guys want to set up this new system now or what? And they're like, yeah, please, because they just got their asses kicked. So he said, okay, sign all of your land over to the crown in this doomsday registry. And that's what they did. They signed all their land over. So at common law, they conveyed the controlling interest of their property to the king. Then the king gifted it back out with rules and regulations attached to it because he now had the controlling interest. And those rules and regulations, those obligations, those became known as feudalism. That's all communism is government centralized control of property and labor by the government under the regulation of the government, right? But that requires everybody to sign over administrative control to the government, what you do with your birth certificate and social security card, driver's license, selective service registration, voting, whatever else, right? You're just signing all of your sovereignty away. But anyways, so now you get the difference between property ownership or allodial title and feudal tenure, right? So we'll pop back over to Wisconsin Constitution. All lands within the state are declared to be allodial and feudal tenures are prohibited, period. Okay. Peg's Place says some in Australia have set up common law courts, but only a few sheriffs and nowhere to hold the plaintiff. It's a start. That is a great start, though. It doesn't matter if you erect a temporary spot. Doesn't matter to hold. And you're saying to hold court, you can hold court anywhere. The substantive definition of court is the sovereign in his suit. That's it. So it's basically the court is a bunch of witnesses where the sovereign can prove that he's right in what he's doing. That's essentially what it is, right? And you can hold it anywhere. I mean, in the Old West here in the United States, they used to just hold it right in the town square. It didn't matter. They didn't have to. They didn't have to have a specific courthouse, which those are just temples of Baal anyway, temples of Moloch, temples of Osiris. It's just black magic ritual places. So you're probably better off to hold court outside of it. AKA court if you're PPW and the ability to stand on it. I'm not sure what you mean by PPW, but and Sergeant Frog Dog says that we've got 2 common law sheriffs here in Ohio that you know of. That's awesome, dude. That's badass. And I would really like to have you up sometime so you can talk about your experience in recreating your MCO if you'd ever be willing to come up or just to shoot the shit. You seem to be pretty knowledgeable and would probably make for good conversation. Not that everyone else doesn't, because you all do, and you're all more than welcome to come up here as long as you stay on topic and all that stuff. But I think that we could really probably put on a good interview for everybody. All right. So this is your property ownership. right? Allodial. Now back to the private express trust. Well, first, actually, before I go to the private express trust, we're going to hop over here to Chisholm v. Georgia, because this is another important aspect, right? This is from 1793, Chisholm v. Georgia, and it tells you, at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. From the differences existing between feudal sovereignties and governments founded on compacts, there's that again, that association of feudalism, because that is what we got away from when we won our independence. But the banking system brought it right back over here, and Congress sold us out. Okay, they're all traitors. They're all treasonous scumbags. Every last one of them. I don't care if they're a donkey or they're an elephant or they claim to be a libertarian. Okay, unless they are trying to get rid of the 14th Amendment, they are a traitor, 100%. It's so simple. You could leave the banks, you can leave the bar associations, but you take away the 14th Amendment and you take away their jurisdictional authority to hold you liable for anything to do with the public debt. So fuck them, right? Anyways, so it says that from the differences existing between feudal sovereignties and governments founded on compacts, it necessarily follows that the respective prerogatives must differ. Now, I know this is a little boring, but bear with me and I'll translate what it means. Sovereignty is the right to govern. A nation or state sovereign is the person or persons in whom that resides. In Europe, the sovereignty is generally ascribed to the prince. And notice they're all princes. They're not kings on the international stage. They're princes because they're all under the Pope in the Holy Roman Empire, the Holy Roman Alliance, which first began when Charlemagne was crowned in the 800s AD. And it was the permanent merger of church and state. And since then, the papacy has controlled all of the monarchs in England. And when he lost control of them, usually some subversive group of, say, Jesuits or small hats or somebody would infiltrate, stage a revolution, have that king or queen beheaded, and then all of a sudden they got back in line. So that's just how it works. So there, the sovereignty is ascribed to a prince. Here, it rests with the people. There, the sovereign actually administers the government. Here, never in a single instance. Our governors are agents of the people and at most stand in the same relation to their sovereign in which regents in Europe stand to their sovereigns. They're our subject, okay? But the 14th Amendment says that you're the subject to the jurisdiction thereof. The United States, the foreign corporation. It literally says the word subject, and that's what they mean by, like, that's why they chose that, and subject to the jurisdiction. You are a subject of under the United States territorial jurisdiction. You're subject. You're no longer sovereign. You're no longer one of we the people. So that brings me to why we're creating our private express trusts in the Jurist Societies. One, most of us have claimed our estates on the record. Okay. And we've also made the claim in such a way that it's a vicious performance contract that only requires tacit agreement to enter into. Okay, and I showed this to you guys, some of it anyways, under the podcast titled Claim Your Estate. So if you haven't seen that one yet, go back just a few episodes ago. It's called Claim Your Estate, and check it out. And I go through and I explain that. Well, once you've done that, right, the private express trust, it's a two-part procedure. The private express trust that you're going to create is a common law contract. Okay. And this common law contract, what happens, you know what else was created by a common law contract? The government. Okay, so you're creating this trust under the same authority which the government was created, which is your natural and unlimited right to contract. And when you create your own private contract at common law outside of the government, then the government essentially it's not a creature of the government, and the government has no interest in it. For all intents and purposes, this trust becomes a natural person at common law outside of the 14th Amendment commercial equity system. Okay. It's never been entered into the trust indenture. It is a natural person at law, because natural person is just somebody who has the capacity for rights, right? And so it has all the same capacities as one of we the people would at common law for property ownership, which is why I showed you what our actual property rights are in this country. They're absolute, or any common law country, they should be outside of government, right? So at least in our country, government was never meant to gain a feudal tenure over us. but they did so with the 14th Amendment, as I've said ad nauseum many times. And just in case you're new to the channel, I pop over here because people are like, oh, you have to be a 14th. Everybody's a 14th Amendment. So everybody's a United States citizen. And it's just so stupid. I hate arguing with people like that because it's like I can prove this 7 ways from Sunday. Anyways, it's right. Oops, what the hell? Okay. It's right here. Okay. This is McDonald v. State. It says that the evidence of bushing on his voir dire, which shows a juror's capacity to be a juror, showed that although he was a citizen of the United States, or although he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of the state and yet not a citizen of the United States. Okay, so we've got that. We've got U.S. v. Anthony, okay, where you come right down here and it says the 14th Amendment defines and declares who shall be citizens of the United States and protects only such rights as are rights belonging to persons as citizens of the United States and not rights belonging to persons as citizens of a state. Two very different classes of citizenship. One is sovereign, the other is subject. Okay, one created the government, the other is a creature of it. In the same capacity with the private express trust, the private express trust you're creating is not a creature of the government, as is the 14th Amendment citizen. Instead, it is a private natural person with all the private property rights that any one of us would be afforded under common law in the original republic. So you create this trust, okay? And so here, let me look for not that part. No, hold on, I'm trying to find where it okay, Barry v. McCourt, this one. The court held that the express trust is a contractual relationship based on trust form. It was held that any law or procedure in its operation denying or obstructing contract rights impairs the contractual obligation and is therefore violative of Article 1, Section 10 of the Constitution. Because the express trust is created by the exercise of the natural right to contract, which cannot be abridged, the agreement, when executed, becomes protected under federally enforceable right of contract law and not under laws passed by any of the several state legislatures. Okay. The court made it clear that the express trust in Elliott v. Freeman was not subject to legislative control. They cannot, and I've checked in Michigan, they barely legislated anything regarding express trusts. The only things that have been legislated in Michigan regarding express trust, and it was all the way back in 1846, and they haven't changed it since because they can't, is they created a way for them to take it over. And that way here in Michigan is if the last trustee dies and there's no other trustee to take the place, right? Automatically the court gets to take the trust over and appoint its own trustees. Sketchy stuff, right? But will you just be aware of that when you create the trust instrument and you don't allow that situation to take that action, right? The other one is if a trustee resigns. Okay. If a trustee resigns, then the court has the first to resign from the trust because this is an actual, you're binding this person. They actually have to go to a court of equity and petition to be released, file a motion to be released as trustee and resign. And then the judge has to grant it, right? So they're locked into that position. But if that takes place, then the judge can actually appoint his own trustee in the place and thereby take over the trust. And so you just be aware of these ways that the judge can, at least in Michigan, I bet all states, but that's all they could do. So there's no rules or regulations regarding the private express trust. I mean, within reason, it says you can't create a private express trust for the commission of crimes. You know, you can't be like, oh, I'm going to create a trust to have people whacked. That's obviously not a thing. You can't do that. It's not John Wick. You're not the Continental. You can't do none of that, right? So let me see here. You got R Dubs 732 says, yeah, the video you're talking about, titled Claim Your Estate, is that on YouTube? Yes, it is. It's just a few streams ago. And yeah, so Yep. So yeah, you guys definitely check that out. Like I said, I don't go through the entire thing, but I go through the basic synopsis of it. And this is the other part of what you do, or that we do in the Jurist Society. And I create all our forms and templates and everything and teach you how to use it. And you just personalize it, you know, and if you have a unique situation, then we work together and figure out what we need to put in there. But then you put your property in private express trust. So let me finish showing what this is all about here. It says it's not subject to legislative control because it's not a creature of the state or a federal corporation, right? So it says it went further to acknowledge the right-wise stance of the United States Supreme Court that the trust relationship comes under the realm of equity. Of course it does, based upon the common law right of contract, and is not subject to legislative restrictions as are corporations and other organizations created by legislative authority. And they're subject to legislative authority because they're created by legislative authority. That's why you don't go file with the court to create a trust. You don't register your trust. You don't get an EIN number for your trust or a TIN number of any kind. Or TIN is kind of redundant when I say number, but a TIN, tax identification number of any kind. You don't do that, okay? Because then you're going to place that legal person that you just created under legislative authority. So you don't do it, okay? Now, what they're saying here about equity, all trusts have to be adjudicated in equity because law doesn't recognize fictions. And law cannot recognize man-made rules and enforce them as law. They just can't. All of this has to go into equity because law is the law. Law is not written. It's only written about. And as we discussed earlier here in the heart of Blackstone, which I thought I had up somewhere. Let me close this. It's probably right next to it. Heart of Blackstone, it tells you the common law is grounded upon the general customs of the realm and includes in it the law of nature, the law of God, the principles and maxims of law, and it's founded upon reason is said to be the perfection of reason acquired by long study, observation, and experience, refined by learned men in all ages. And it's long study of the law. You discover the law. You don't create law. But see, these megalomaniac Roman civil law parasites think they can create law. Well, they can if they can reduce you to property, but it's not creating law. It's just regulating property. So they turn you into chattel property and trustee of your own estate. Take the estate under administration. Now they can make all the needful rules they want regulating the use of that property. Don't drive faster than, well, first of all, if you're in a motor or if you're in an automobile, it's now a motor vehicle because you're always engaged in commerce. And you're driving, so you're employed on behalf of the state because it's the state's advertisement that's on the back of the car. Says like the license plate will say Michigan or South Carolina, where that's the state's property, and you are employed to use it, and they don't pay you. So I've actually heard of one guy asking the judge, like, "Don't you guys owe me money if I'm here on a motor vehicle violation, right? Motor vehicle code violation? Don't you guys owe me money because that must mean I'm employed by you?" And that is technically the scenario of what they're doing. When they afford you a license, the license is for engaging in commercial activity. That's, even though it's not a commercial license per se on its face, it is all licenses to drive because driving is a commercial term. I pulled up Black's Law 4th edition earlier, but it's on another window, and it tells you under the definition of driver, one employed to conduct a coach or carriage. Right, motor vehicle in the United States Code is any contrivance or conveyance, whether self-propelled or drawn by a horse, right, that is used for commercial purposes. It doesn't say or used for commercial purposes. It says and used for commercial purposes, which means it must be commercial, right? So yes, driver defined, one employed, exactly, as Affle's Gertra says, for sure. So, and you have to go there because the only thing that man can do, man can't make law. They can only regulate commerce and property of incompetents and infants under administration. That's it. They just regulate the use of property. And so that's the loophole. That's how they create these governments, these systems of government like communism, is they convince the people to give all controlling interest of all property to the government, including themselves. Right, controlling interest of themselves as property, and thereby the government can now regulate all property and labor within the state, just like they do in Chinese communism. But they're not making law. They're just making rules and regulations regarding the use of property that they have a superior interest in. Only God can create law, guys. That's it. Point blank, period. And just like in the Credit River decision we were reading, only God can create something out of nothing, something of value out of nothing, not the Federal Reserve piracy system. Okay. So, all right. To clarify, the equity and common law distinctions, the basis of the express trust. Oh, that's what I was explaining about equity. So law, because it is the nature of what it is, it's harsh and just cut and dry, black and white, doesn't deal in future instances. There could never be a DUI at common law because that's a pre-crime. Okay. That's, you're getting in trouble for what you could have done and being treated as if you did do it, right? As you could have hurt somebody. So we're going to treat you as if you did hurt somebody and punish you accordingly. Well, that's a pre-crime, and that can only happen in a court of equity. Okay. As a result of a contract, which is your driver's license contract, it places you under the motor vehicle code. So stuff like that has to be adjudicated in equity. Law would never, ever, ever be able to deal with something like an injunction, where you're going to stop somebody from doing something in the future. There's no such action at law. You can't do something. You can't prevent somebody from doing something in the future. It only deals with what has happened and what is now, not what could be, what might be, what exists in the realm of fantasy, where you've got this trustee and that trustee and this set of rules regarding the use of property that was created by a contract. None of that stuff can be dealt with at law, so it has to go to equity. Now, with that being said, you are creating this private express trust out of your common law right to contract, which means that this trust is now a legal person with all of the common law property rights that one of we the people would have. It doesn't mean that you're able to use the trust at law, right? Because it still has to be, if you're to compel a trustee to do something within the trust, that has to be done in equity. It can't be done at law. But not to confuse everybody, it has all the common law property ownership capacity that one of we the people would have, because it exists outside of the authority of the state, and it's made under the law of the land in your particular state, which is common. It's common law in every state, right? Except Louisiana. Louisiana has always been Roman civil law. It's always been Napoleonic code. But that's another thing I think they did on purpose. Thomas Jefferson, that was a way to essentially infect our republic with a foreign law. But I'm not going to get into that tonight. There's a lot of trickery, a lot of fuckery being done around the founding of this country. But ultimately, they had to give us our sovereignty so that their corporations could steal it. Okay. Well, this is how we take it back. Okay. You claim your estate, then you put your property outside of their reach. So it says, to clarify the equity and the common law distinctions, the basis for the express trust under the common law in this instance is not that such organizations are creatures of common law as distinguished from equity, but that they are created under the common law of contracts and do not depend upon any statute, right? And so, let's see here. We go down here. Okay, a generally unknown fact is that there are several types of citizens now existing in America. The trustees of an express trust may seek protection under the Constitution as state citizens throughout the Union of States, a jurisdiction outside the scope of the 14th Amendment, which we will discuss in a later section, which I discuss ad nauseum all the time, so you guys already know what that is. However, it should also be noted, of all citizenship, the 14th Amendment or otherwise, that jurisdiction over natural and artificial persons is distinguished without a fundamental difference. This stems surprisingly from the operation of in rem jurisdiction. It's actually quasi in rem, which underlies all civil law. So I'll translate that. That's lawyer speak for Roman civil law reduces everyone to property so that it can pull you into in rem jurisdiction, which is essentially admiralty, treating you as a vessel. Right. But the point is it treats you as a non-living entity, as a thing. In rem means against the thing, as I'm sure in ref knows. All right. Have a good night, Jeff. Sorry, I just seen that. He said he's going to bed. Got an early AM arising. Okay, man. Well, good to have you. All right. So, yeah, Jeff is already, he knows what we're talking about, because this, like I said, this is what we're going over in the Jurist Society, and he's part of the Jurist Society. So we've read this whole book and then some, and and I'm the one drafting the private express trust declaration, the trust instrument. So Though all courts are familiar with the action in personam against persons, which again, a person is a persona. It's a character. It's a mask that one wears as their role in society. It's not living men and women. So you don't have personas at law. You just have living men and women. That's it. Well, originally not women, obviously, but that wasn't, and I have to clarify this because people think that's like a primitive thing, but it was actually chivalrous, and I'll explain why. The same reason that you wouldn't send your woman to go fight in a war is the same reason you didn't send her to battle in a court. Okay, the paterfamilias, the man, went and represented the house in a legal capacity as the paterfamilias of the house, and he did so because that's who does the fighting and protecting in a traditional relationship. I'm not saying all the time, and I don't want to hear any feminist garbage about this or that. This is just how things worked when society was traditional and, you know, the nuclear family was strong and things were prosperous. So, all right. Courts are, though all courts are familiar with the action in personam, it is the action in rem against things, which, though practiced only in maritime law, stealthily operates in every civil and criminal court. This principle is one of the least understood in its entirety. Well, I'll try to make it simple. So they're bringing you in as property, okay? Your property of the estate. It's actually the estate that is being called in for a violation of the trust indenture, right? But you as the trustee are the one held responsible for performing the obligations placed on it. So they're bringing you in as property of the estate, okay, as a trustee and chattel property of the estate, meaning you don't have the controlling interest of the estate. No, that's daddy government that has that under the Roman civil law system. But you do have the capacity to sue on behalf of the estate and to be sued. So they call it quasi in rem jurisdiction, because you're property, but you're property with the capacity to do some things that people can do. So it's kind of a weird little fictional thing. So that's about the best you can explain it. And the more that you learn about law, you'll understand what I mean, because it's you're just chattel property of your state. That's the only way to look at it. So that's why they can bring you in and the judge can do whatever he wants. And they don't have to give you a jury trial. They don't have to listen to the jury, because the jury is only advisory, like it would be to a king. Basically, the jury is just advisory to the judge. That's it. And he can overrule the jury because you're not at law. You're not at common law. You are in equity. And in equity, the judge's conscience is king. Okay. So in rem jurisdiction over a man or woman can only exist if the man or woman is a slave, i.e. property, or res, meaning the content of a trust, right? In which case his case or her disposition at law is no different than if he or she were a horse or other goods. Okay. And that's, see the Zong, Gregson versus Gilbert. And I actually did look that up. That's in the English Reports 99. And it's basically where this slave ship it ran out of fresh water and was running low on supplies. So they started hooking slaves overboard into the ocean to try to save the rest of them, so they could, because they were looking at it. And so when they brought it to court, they were trying to get the insurance to cover it, and basically the court dictated that we're not talking about throwing people overboard. We're talking about throwing goods overboard, because these people were chattel property. Therefore, they're not actually people. They're property. They're goods, right? That's how they look at you. They look at you as chattel property. I know they do. For a fact, I have proof of it, actually. Well, I always have proof of it, tons of proof of it, but where is this DNC? It's right here. This DNC thing, you remember when the whole Russia collusion and all the puppet show, the right-left paradigm, where they try to make you think that one's the white hats, the other one's the bad guys, and daddy government's going to fix itself and save you and all that stuff, right? Well, the document that they actually did file against old Trump and Russia and Julian Assange and everybody, right, was for influencing the outcome of the election, right? And look at how they put it as a crime at law, an actionable offense. It says trespass to chattels, conspiracy to commit trespass to chattels. Well, that trespass to chattels is saying that essentially Russia and them messed with the DNC's property. The DNC's property is their voter base, the registered voter base. Okay. That's chattel property to them. And they're telling you right here. So, yeah, indenture does say it all. Yeah. It's what it is. It's what indentures were. So, and then they would just extend the indenture indefinitely. So, and RDubs, the Jurist Society, is the membership program for the channel. But I mean, of course, hang out for a while and see that what I actually teach and all that before you jump right into it. Make sure it's something that you want to do, because it's definitely not. It takes a lot of learning on your part. I'm willing to help and I'm willing to teach, but there's a lot of learning involved, a lot of material to go over, and it's going to require you to fundamentally change the way that you look at things. So, like I say, you can see that I 100% bring all the receipts. That's why I'm saying hang out in the regular channel for a while and just see that I bring all the receipts and all that stuff, and that I actually know what I'm talking about. And then you can decide from there, is my advice. But anyway, all right, let's hop back over to this Weiss Concise Trustee Handbook. So, in nature, in rem jurisdiction is exercised over men and women by their creator exclusively, because that's the only entity that we are property of, is the creator. Governments can therefore gain only a fictional in rem jurisdiction over men by creating various legal devices, personas, for those men to assume limited control, e.g. citizen, taxpayer, driver, etc. Since the device is a legal fiction, a falsehood made true by force of law, that's exactly what it is, a falsehood made true by force of law. This, and not even actually law. Well, yeah, because the contract, right? And common law has to acknowledge the validity of the contract if there's a meeting of the minds and you willingly consented, which you did not to the 14th Amendment, which is how we undo that with the claim. This persona is in fact a legal object or res, just as in theater. The persona, person, is separate from the man or woman playing the part. Therefore, there may be artificial persons, but not artificial men. Natural persons, but not natural men, right? So, and the word person obviously includes entities, businesses, etc. So, let me see here. So this is a good thing to go through. Yeah, Santa Clara County versus Southern Pacific Railroad is the one where they were able to dictate that corporations were persons, right? And man's right to contract is considered so fundamental that even under Roman law and its system of domestic slavery, which is what it is, all men, citizen or not, with the exception of slaves, retain this fundamental right, ius gentium. It is understood to derive from a man's creator and therefore is unalienable. And that's still held true today with your common law capacity to contract, your natural right to contract. Even though you're under this Roman civil law trust indenture system, if you haven't claimed your estate, you still have the unlimited right to contract because, well, they've got to be able to snare you some more. So if they stopped that, then they would shoot themselves in the foot. But beyond that, well, let me go through and there's one more instance where it shows you. There's a Supreme Court case that tells you that you're not subject to public policy. The trust is not subject to public policy unless it affects the public interest, essentially. So, let me see where that's at. Adequate provision. No, it's in the notes somewhere. And so the trustee, no. The contract makes the law. That's important to know. Indemnified. Well, anyways, I'll just explain it without finding it real quick because I'll stay here and bore you guys to death looking through this. But basically what it says is that so long as the trust is not subject to public policy unless it affects public interest, and then it only comes under public policy so far as it affects the public interest. Okay, so your private express trust, let's say you wanted to open a restaurant with the private express trust. Well, since now you're selling food to the public, right, and the public is primarily comprised of 14th Amendment infant chattels, property of the federal corporation, now you're going to become subject to all the FDA and food quality licensing and public policy, right? So that's how. Now, if you create a private membership association, right, and you make you charge members a fee to join, but then make whatever product that you're selling a gift, then it circumvents the public policy and it exists outside of the public purview, and there's nothing they can do. So very important. All right. Now here's the big crux of what we're doing with the private express trust. So we're creating the trust, and I'm going to give you guys an example. Say that I create an automobile, or no, I don't create an automobile. I'm not God, right? But say that I make my automobile part of the trust. So you had to transfer the asset into the trust. I would sell. So when you create the trust is entirely a separate legal person from you, and you have to treat it as such all the time, even if you're the trustee. But when you're dealing with it from outside the trust, like say you're transferring some of your own assets into the trust, then you're wearing two hats. You're acting as the seller outside the trust, then you're acting as the buyer, the trustee, on behalf of the trust. And you've got to do that to a T. There's nothing technically against it, right? But you have to do it perfectly and without any kind of unfair advantage on your behalf. And that's something that we go through later. I'm not going to get off into that, but so you're selling it to the trust. And then as the trustee, you're buying it for the trust, but the trust is actually buying it. You're just the instrument by which things are done. It's still all the trust, all this separate legal person, right? And so you're going to sell your automobile to the trust for, say, 20 silver ounces, which would be the equivalent of 20 common law dollars. And anything $20 or over in the Constitution is subject to the common law, right? So that's why you're going to sell it for 20 silver dollars. And it's right in the Constitution. And so when you sell it, you drop a bill of sale and you give that to the trust. And then the trust, it goes in the trust paperwork and all that stuff, right? Now, the terms of the trust, when you create the trust, is none of the property in the trust can be used to engage in commercial securities transactions, because that would violate Article 1, Section 10 of the Constitution, and the trust must maintain accordance with the law of the land because it's a private express trust. So you cannot engage in any of the commercial securities scheme whatsoever, right? So now, what happens when you're traveling in this trust, or traveling in this automobile, the automobile belongs to the trust. Okay. You can even have the trust issue it a registration number being registered with the trust, right? And put that registration number on your plate and make sure all of this is on the public record. And when the cop pulls you over and says, why don't you have a state plate? Say, well, this property is not under administration. It's not concerned with the public interest. It's not subject to public policy as per the trust indenture, right? As per the trust instrument. This property must maintain accordance with Article 1, Section 10 of the Constitution and is not to be used for commercial purposes under any circumstances whatsoever. And for that officer or that court to compel you to register that vehicle with the state, or that automobile with the state, and make it a vehicle, or for him to compel you to present a license while using it, which automatically puts you in commerce, right? He's compelling you to violate the obligations of a contract in direct violation of Article 1, Section 10. And if they cause you injury and they seize your property, it's not your property, first of all. So that's how you have to change the way you look at it. It's not your property. It's property of the trust, right? You have to, if he causes you injury and takes the property of the trust, then he's actually broken the law, violated the Constitution, and you have a full-on lawsuit on your hands on behalf of the trust. And the trust is about to make a lot of money from the officer. So, and the cool thing about that is you can enforce that in their own courts, right? Because it is a private person. It is living in the private, is operating in the private, or it's existing. It doesn't live. It's a non-living entity, but it's existing in the private, outside of the commercial scheme, outside of the 14th Amendment. Now, I have to say the commercial aspect of it is my idea. Right. I came up with that instantly. As soon as I came across this book and the concept of private express trust, I'm like, and this is probably about a year ago, I was like, this is brilliant. this will go perfectly in tandem with the claiming the estate. And the reason being is because it's a natural person with all the common law capacities that one of we the people would have, right? And so I came up with the commercial aspect of it, but the whole using the private express trust is from this guy, Carlton Weiss. And Carlton Weiss, let me tell you who he was, or who he is, if he's still alive. I'm not sure, I haven't looked, but he was a lawyer for big corporations that had trouble with people like me and people like you guys who were causing problems for these various corporate institutions. And they're like, dude, you got to come in and help us deal with these sovereign people, right? Well, that was his area of expertise. And he would go through and he would find where we messed up, and then he would shut us down, right? And very interesting, because there's not many lawyers that are even capable of doing that, but he's one of them. And so when he retired from doing that, he wrote this book. It's called Weiss Concise Trustee Handbook. And he goes, you know, all these people, if they would have just done this and created a private express trust like the Rockefellers and the Carnegies and all those guys had done, then they could protect their property and keep it outside of the commercial system. And that's where I got the idea of, well, why don't you just put it in a trust indenture, not to be used for commercial purposes under any circumstances whatsoever, and to make it so that you're not avoiding public policy, because that would be against the maxims of equity. You put that the reason that it is doing so is to maintain accordance with the law of the land and the Constitution, right? So the trust cannot touch Federal Reserve securities, cannot touch anything that is dealing with that system at all, which includes all the licensing, registration, because you have to register your property so it can be linked to the Social Security number and held in trust as collateral for the public debt. So these road pirates can come make attachments to it, right? And generate their own commercial paper. So that's the trust indenture, or the private express trust, ultimately, in a nutshell. That's why we do this. And yeah, it's actually epic. It's a brilliant idea. And like I said, I can't take credit for it, because it's the wealthy people. That's why it works so well, is because they've used it for themselves. This is a loophole they created for themselves that they probably wish that nobody would ever find out about, but well, we know about it. So let's pop over to, I'm going to show you guys one more thing before I shut down tonight, because I do also have to get up early in the morning, but I wanted to do a little stream for you guys, give you guys some information. Let's go to Mega. So this is the folder I have for the Jurist Society. I'll show you guys. Well, this is my backup information in general. So I've got way more files in the file thing, but I got a ton of files in the Jurist Society. This is the folder for the Jurist Society. My other folder has, I study a lot of different stuff. So it's not just pertaining to law. There's a lot of esoteric stuff, et cetera, et cetera. But so when you open this up, one of our fellow jurists, Eddie, hold the line, he was kind enough to organize this into folders, which makes it excellent to navigate. And so we've got, and I'll show you some of the documents, we've got tons of books. Pied Pipers of Babylon's awesome. Fundamentals of Procedure, Common Law Pleadings and Practice, which with forms, annotated forms that can show you how to do it. Of course, the Credit River stuff, got multiple law dictionaries, got treaties on life insurance, treaties on the law of trusts, treaties upon general law actions. I've got an entire collection of American law books. It's not Amjur, but it's American Law and Procedure, and it's tons and tons of those books. So anyways, American Law of Administration, this is an excellent book. But the most important thing is I have templates. And some of these templates I've gotten from other places. A lot of them I've just drafted on my own. And this is the claim. Okay. So lawful claim of title, will, execution of will, declaration of status, appointment of trustees, and standing orders for the same. And what I wanted to read for you guys, yeah, if you've got some Amjur, that'd be awesome, dude, because I've been looking for Amjur so hard to find. So yeah, it's burn the corporate fiction at yahoo.com. if you've got a link or something, you can swap some treaties. But all right, so this right here, I wanted to read you guys the conclusion, right? This is the conclusion. This I worked very hard on, and when I wrote this, I got to be honest, I felt inspired. I honestly did. I was like, wow, these aren't even my words coming out of here. That's pretty cool. So this is when they get through the whole thing, and like I said, the claim operates as a performance contract, a declaration at law, and a claim of title, right? And also it creates a private express trust, but not the one you want to put your property in. This creates a private express trust that whoever's administering your estate enters into by tacit agreement, which means by their continued actions. And they have to put up a $33 million bond. This claim has already worked. Okay, Daniel A. Wazzle in the state of Colorado. You can go on the Secretary of State's website. Actually, I will go on that in a second just to prove it, because every time I show this, I got to prove, because it seems so beyond belief, but it's not. It works. And it works because once you reverse engineer what they've done to get you in this position, once you know that it's the Magna Carta that they ultimately use, the administrative provisions in the Magna Carta, the Set the KV Acts, the Poor Laws, Settlement Acts, obviously the 14th Amendment, and just basic fundamental operations of law that most people are ignorant of because they just don't teach it these days. You've got to actually read these old treaties and know law isn't written. It can only be written about. And these fundamental processes of law are in operation, whether there's a statute created about it or not, whether there's an enactment created, like when somebody becomes dependent, right? So, and I promise I'll get right back to this, but I'm going to show you guys this just for the sake of illustrating my point. Nope, that's about equity. Okay, so a state of dependence will inevitably oblige the inferior to take on the will, or take the will of him on whom he depends as the rule of his conduct. Okay, that's what the 14th Amendment does. It's, first of all, the 14th Amendment exists at the pleasure of the United States corporation, the federal corporation. It is a creature of that corporation, and all of the privileges, immunities, benefits, and protections that it offers, right, are dependencies. And as soon as you accept that, you automatically agree to take on the will of the federal corporation. And that's how they were able to mortgage your estates in 1933. It's that fundamental operation of law, that's ancient understanding of law and the ancient system of pledging, that they keep hidden from the masses, that they know they can just use. There doesn't have to be an enactment or a statute or nothing. If you come under the administration of the federal corporation, then it's long been held that the administrator, right, the guardian, the parens patriae, the government as parent, can mortgage any portion of the estate or all of the estate if it's for the benefit of the estate. Okay? As long as everything that they do is for your quote unquote benefit, then they can do it, which is why they put everything under health and welfare. I'll show you something else real quick that's kind of funny. Is you go to Title 42, right? And yeah, here, check this out. This will illustrate my point perfectly. So look at this. This is Title 42, Public Health and Welfare. The National Space Program. What? Well, they have to put, because they wanted to appropriate money against your estates in order to create this bullshit space program. So they had to put it under health and welfare, and they have to start every single sentence with this, or every single paragraph with this. The Congress declares that the general welfare and security, there's your benefits and protection, welfare and security, right? Congress declares that the general welfare of the United States, right? Like it keeps going. The Congress declares that the general welfare of the United States, and they have to put it that way so that they can appropriate money claiming that it's for your benefit, even though, have you benefited from the space program? No. All right. Good night. I think Pat's leaving. You're going to bed? Yeah. Okay. Right on. I will, I'll see you next time, Pat. So, yeah, it has to be at least pretended. This is what I call philanthropathy, right? Like psychopaths, but they pretend like they're doing good stuff for you. Like Bill Gates going around forcing the jibbity jab on everybody for their benefit. You know, if if we do a really good job on increasing vaccines and ensuring healthy reproductive measures, we could see a decrease in population by 10 to 15% over the next 20 years. What? Well, that's for your benefit, though, because you see, decreasing the population, that's for your benefit, right? You selfish bastard. You should just go ahead and not exist anymore. But anyways, let's hop back over to Mega, shall we? Shit, I hate when I do that. Now it's behind. All right, we're going to close Credit River. We're going to close that. There we go. Okay. So I'm going to read this conclusion for you guys, take a few questions, and then I'm going to shut her down for the evening. But it says, the estate of claimant is that upon which his life depends, which primarily consists of his personality, labor, and property. And as such, the estate is evinced as the highest realization of the free will of claimant. Okay? So I'll translate that because I definitely got into lawyer speak here. The estate of claimant is that upon which his life depends. So obviously, your estate is every piece of property that you have interest in and your ability to acquire property. The substantive definition of an estate, everybody has an estate. The wealthy guy that's got the big gated land, that's obviously a stately estate, right? And the homeless guy on the corner begging for change, he has an estate, because ultimately, even when you have nothing, your estate is the capacity to labor towards property. That's what they mortgaged in 1933. It's your capacity to labor towards property. That's why you pay income tax on labor. Your labor has been mortgaged. That's insane, right? Right? So not just your property, but your ability to acquire it is taxed. That's insane. Okay? These people are scumbags of the highest order. Or lowest, depending on how you want to look at it. So, and it says, and as such, the state is evinced, which is essentially means shown to be, right? The highest realization of free will of claimant, right? So, and this goes back to the American law of administration. I can't take credit for that. I didn't come to that realization on my own. I got that from J.G. Warner, and then it fundamentally transformed the way that I look at property. All your rights are derived from property. And he says, my property is that which is mine. I will something to become mine in order to serve my will as my bodily limbs serve me. Okay. Hence, my property is the highest realization of my will, right? He says, matter is unfree. Its nature is to offer resistance. So my will, in overcoming that nature, that resistance, right, consumes it and transforms it, infuses it with my essence, and makes it my property to serve my will. So your property is the highest realization of your will. It's such a sacred, holy thing for these parasites to believe that they could reach in and tax your ability to acquire property before you even get it. Income tax is just mind-blowing, dude. And you think that the colonists fought the Revolutionary War because England took away their power to control their own currency. It wasn't taxation without representation or any of that horse shit. It was they took away the colonial script and then made them pay all their taxes in gold. Okay. They never would have dreamed that somebody would be able to reach in and take their wages, dude. It's wild. It pisses me off every time I think about it. All right. So, as the people of this republic are all equal before Almighty God and superior to the ens legis, which is creatures of law, they create, no one has the lawful right to subjugate the free will of another so long as they are found to possess one without consent. Now, I added that in there because that's fair. Common law provides that you can come under administration if you're an incompetent or you're not of age, right? So if you're a drunkard, a spendthrift, a lunatic, a moron, or you're not of age, then you're not considered to have a capacity for free will. And therefore, you are just like property. You're unfree, and your nature is to offer resistance. And so the administrator, in realizing their will, overcomes your resistance and subjects you to their will as property. This is the whole basis of Roman civil law. Talk of taxing spare bedrooms. Peck's Place says talk of taxing spare bedrooms over here. Damn, dude. Australia is wild. That's wild, man. Holy shit. Yeah, a lot of people talking about the future population, not going to be, yeah, I know. Well, that's why they're bringing in all the third world people, because those are the people that weren't jibbity jabbed up And those are the more subservient and dependent populations that they want to replace the existing populations with, so that they can set up their AI governance infrastructure and just totally micromanage every aspect of everybody's lives, because they're psychopaths. These people are fucking psychopaths, dude. Psychopaths, right? Like unbelievable degree of megalomania to believe that they somehow have the right to do this. So now that you guys know what I meant by as long as they are found to possess one, right? So it says, as the people of the Republic are all equal before Almighty God. And really, it's not just the Republic, it's everywhere, right? Australia, Canada, like the people are equal before Almighty God, period. As long as they have free will, right? Or capacity to exercise it. So as the people of this republic are all equal before Almighty God and superior to the ends legis they create, no one has the lawful right to subjugate the free will of another, so long as they are found to possess one without consent, because you can contract that free will away. This claim stands as notice to the world of the free will of claimant on perpetual record, right? So this claim stands as notice to the world of the free will of claimant on perpetual record, and serves to dispel all erroneous presumptions about claimant, thereby removing the estate from all jurisdictions except that of the common law, which may have been assumed without such notice. It is the intention of claimant, upon recording and serving this claim, to have full redemption of the estate, receive a full and proper accounting of all property which has been heretofore under administration, and settle the same, to claim as birthright and inheritance absolute dominion over and executive control of all property of the estate, collapse, revoke, and or terminate all trust derived from the property of the estate, which claimant himself has not by his will created, to return claimant and the estate to the proper state of dignity as soon as reasonably practicable, and to have acknowledgement and understanding by all that an establishment of a freehold in law has been created by operation of law, so that no further unwanted administration of claimant, the estate, or any trust derived therefrom can occur at any time hereafter. Claimant has been made aware of fiduciary malfeasance, fraud, maladministration, unlawful arrest, false imprisonment, common law theft, deprivation of rights under the color of law, trafficking, human trafficking, inland piracy, corruption, moral depravity, and destruction of the right of claimant to blood and kinship being carried out against the estate by known and unknown men, women, actors, persons, officials, and other entities. Therefore, whenever any form of government becomes destructive and antithetical to the very purpose of formation, that being to secure the inalienable rights of the people, it is the absolute right of claimant, as one of the sovereign people whom that government serves, to alter or abolish that government. Claimant finds and holds that it is necessary for the security of claimant's life and exercise of claimant's unalienable rights to solemnly declare, decree, and record upon the public record everything stated herein, in order that claimant, by the expression of his will, shall secure the protections, appointments, claims, orders, instructions, agreements established by this claim. And then I've got these court cases here. That the majority shall prevail is a rule posterior to the formation of government and results from it, not a rule binding upon mankind in their natural state. There, every man is independent of all laws except those prescribed by nature. This is on the record for me. This is on my county record right now. They can suck one for sure. He is not bound by any institutions formed by his fellow men without his consent. And that's Cruden v. Neal, right? From 1796. And then this one is from McDonald v. State, which I've shown you guys today. The evidence of Bushing on his voir dire showed that although he was not a citizen of the United States, he was a citizen and voter of the state. One may be a citizen of a state and yet not a citizen of the United States. McDonald v. State, 90 Indiana Supreme Court, right? And that's from 1887, I want to say. Or no, 1883. Anyways. Furthermore, whereas the de jure form of constitutional government has been silently replaced by the United States territorial occupation of the several sovereign states, and by fraud, coercion, collusion, and misrepresentation of material facts, usurp the citizenry thereof by contract and pledge under the 14th Amendment of the Constitution. And whereas the President and Congress have acted as proxy settlers for the estates of all 14th Amendment federal citizenry, to be used as surety for the Federal Reserve security scheme, thereby barring access to lawful money and the law of the land, common law. A new form of administrative government and law has been quietly established without the knowledge or consent of the people, which is why I put this case up here, right? It says that the whole purpose of Cruden v. Neal was when a new form of government is formed, all men return to a state of nature and must consent to come under that new form of government. Well, that's why I went on to explain, you guys created an entirely new form of government quietly without the knowledge or consent of anybody. Okay. And so that's why I said it's been quietly established without the knowledge or consent of the people. That's why Cruden v. Neal applies. That's why I put it there. This claim hereby rebuts all presumptions that would place the estate under administration or allow the property thereof to be used as surety, which is security, collateral, by any person, government, corporation, or any other entity, and hereby stands as an absolute withdrawal of consent, which was never formally given by claimant to be administered and or governed by any government, corporation, and or administrative rulemaking agency foreign to the people of the several states, which they are. Claimant finds that it is absolutely necessary for the salvation of claimant that he be subject only to common law, as it is the societal implementation of divine revelation in the preliminary law of nature, standing as one of the sovereign people, being equal with the peerage before Almighty God. Furthermore, claimant does not consent to be subject to any revealed or unrevealed contracts, trusts, pledges, bonds, acts, statutes, codes, ordinances, rules, regulations, canons, bulls, homages, fide commissum, or presumptions which would deny, contradict, diminish, deplete, violate, or supersede anything contained herein, and claimant hereby revokes, rescinds, rejects, terminates, and forever prohibits consent, presumptive or actual, to be bound by or subject to the same. And it's nunc pro tunc et usque ad finem temporis, which means from before till now and forever, right? And then the witness quorum and acknowledgement, my jurat. And then I have a little bit of extra law because I have a seal. So to many jurists, I have a house seal. I've established it. That's also on the public record. And it tells you when a seal is affixed to an instrument, it makes it a specialty. Whether the seal be affixed by a corporation or individual, the effect is the same. And that's from Bouvier's Law Dictionary, 1856. It also serves as its own consideration, right? So it proves itself. That's in Bouvier's Law Dictionary. So the seal of a foreign state proves itself. It stands as its own honor, its own value. That's why you have to seal it. And everybody had a seal in the 1800s. Everyone who was anyone had a seal. For instance, in Indiana, when they established the schedule for when the government was to be enacted and start taking place, it said whoever is elected governor of the state shall use his private seal until a public seal can be made for him, which tells you that they already assumed that whoever would be elected governor would have a house seal. It's how common law, it's your very first layer of political protection. See, what the states actually were, and really any common law country when they originally started, what they actually were was a collection of houses. And in the United States, it was a collection of sovereign houses, estates, that the collective was thereby called a state, right? But it was made up of sovereign estates. It's not the government of the state that's sovereign, and it never has been. And it's not the government of the state that is the state, right? The state is the people, and it is a free state because the people are free. Not to the government. The government, by definition and by the nature of what it is bound to an indenture of service and cannot be above you. And that's how that works. So I wanted to show you guys that. I thought you guys might like that. Whoops, damn it. I did have another thing I wanted to show you guys. The notice of liability. So let me show you that real quick. So then, now when I have to send that to somebody and they shit themselves, when I do, they don't want to mess with it because it's a dangerous performance contract too. And plus it rebuts everything that they're doing. I send this notice of liability that I drafted up too, right? So And I can make these, I can draft these things I got really good at making legal documents. Let's just put it that way. And I can make them look nice just like this. And also you'll notice the zip code is in parentheses because anything in parentheses or brackets is technically not on the page. Look at this. Sergeant Frog Dog says, it's strange talking about this because I literally just placed a seal on one of my trust documents. Exactly. You got to seal all your trust documents for sure. And the seal is actually very easy to get. I got a nice one, an embosser, a desk embosser that's also converted to a pocket embosser if I ever need it, to be with a bunch of the seal stickers, gold seal stickers, which are great. Because when you get an embosser, you can generally only get it either a bottom, left, right, or top embosser. But depending on where the signature line is on whatever document that you're drafting, it could be the bottom, it could be the middle, it could be on, middle right or whatever the case may be, or it could be closer to the top. And so when you get the stickers, you can just seal the sticker, emboss the sticker, and then put the sticker wherever you want it. And so it's very, very key to get those embossment stickers for sure, because then you don't have to worry about which direction your seal embosses from. You just emboss a sticker, put it wherever you need to be. So, but anyways, this is a pretty sweet little notice of liability I drafted up after I filed my claim on the record. It says, know all to whom these presents shall come, which is just an old common law way of saying greetings, right? Any administration hereafter this notice, whether attempted or actual, of the Ryan Mason Wells estate, hereinafter referred to as estate, that way I don't have to keep saying Ryan Mason Wells estate, including all item sonins or variations thereof, which item sonins are names that sound the same or are spelt similar, right, and can be construed as being the same. And they have this little item sonins thing so that they can put your name in all capital letters and pronounce it as your name, but technically it's not you, it's the trustee, the legal fiction that they created, attached to the social security number. But because of item sonins, they can apply it to you, right? So I tell them, including all item sonins and variations thereof, any property thereof, or any trust derived therefrom, including but not limited to constructive trust, shall stand as tacit agreement to the performance contract set forth in Muskegon County Public Record number 5846165 under Lieber, which means book, 4380, page 614. There's my public record in Muskegon County. Any single one of you can look that up. You can look this up on Muskegon County. That's what makes it the highest form of evidence at law, is because when you put it on the public record and then you serve it to everybody, it stands as lawful notice to the world. And in the claim, I give them 30 days to state a superior claim or forever relinquish any administrative interest they have in it. And so I serve everybody, and then 30 days go by. Of course, nobody's going to say, no, you're actually a slave. I have a superior. Nobody's going to do that. So boom, it's the highest form of evidence at law. That's why it works. This is how they've done it back in England when the Set the KV Act was passed and they took everyone's estates under administration. This is how you got out, is you had to do an action at law on the record stating that you're alive. That's where the idea from the claim ultimately comes from, right? And so the estate has been claimed as evidenced in the public record, is not under administration of the state nor the United States, and is without the territorial jurisdiction of the United States and the administrative rulemaking agencies such as the DMV, IRS, EPA. All those are administrative rulemaking agencies that are little quasi-private corporations that are acting on behalf of the Federal Reserve System and are only given the authority to do so by the United States because they have to, because of the debt. So the rulemaking agencies acting on its behalf, the heir and claimant of the estate is one of the people of the state of Michigan, as evidenced by the public record listed above, and has lawfully rebutted presumption of inferior status of the inferior status of a United States citizen. This being a creature of the 14th Amendment of the Constitution of the United States, All property of the estate is under the House of Wells and is not subject to any hypothecation or contract not bearing the seal of the House of Wells, accompanied by the signature of the paterfamilias thereof, which is the basically the head man. But you can be a materfamilias as well if your husband's not, because things are different now than they were before. So you can just be, we've got quite a few female jurists, and and their husbands aren't interested in, that's just not their thing. And so, these women are taking the reins, which kicks ass. And so you'll just be the materfamilias of the house, right? Any attempted administration, including but not limited to holding an administrative hearing in an attempt to reduce the heir to usufructuary trustee of his own estate. Okay, I should probably translate that for you guys. So any attempted administration, including but not limited to, because if you just say including, then it would mean only this. That's important. That's why you say including but not limited to. Including but not limited to holding an administrative hearing, which is what these little inferior courts are doing. It's just they're just administrative hearings under the Administrative Procedures Act, right? Whatever your state happened to adopt it. And what they're doing is they're compelling the trustee to answer for his breach of trust and not using the property the way that the administrators told him to. And so that's why I say here, administrative hearing in an attempt to reduce the heir to usufructuary, which means only having the right of use. That's feudalism, right? You use property for the benefit of someone else. And that's what the United States is having you do with the estate. You're using the estate for the benefit of the United States, right? So you're not the beneficiary. They can consider you in some circumstances as a beneficiary only because you're part of the United States corporation. You're an enfranchisement. So what benefits the United States benefits you. But most of the time, they just treat you as a usufructuary trustee, right? Charged with the responsibility of carrying out the obligations of the trust. So his own estate, reduce the heir to usufructuary trustee of his own estate and compel him to answer for the presumed set decay use of the property, okay, which would be the United States is his set decay use. Shall stand as tacit agreement to perform the obligations set forth in the public record and be liable for the bond required to indemnify the estate against any fiduciary and or administrative malfeasance. Thank you for your time and attention to this matter. And then just so they can't say, oh, that's paper terrorism, you're threatening the court. I say this is not a threat, but a legal consequence under Michigan Compiled Laws 566.132 and Title 9 USC Section 2. And that basically just says, contracts, contracts are valid. Like you're entering a contract, it's not a threat. So, and this is the authority for contracts. So that's a legal consequence. But anyway, yeah, so that's pretty much my presentation this evening on some private express trusts and various other things, monetary system, credit river decision, various points of interest. Let me see if you guys have anything going on in the chat here. Let me go back a little bit. So our safety and impotence is their top priority. That's true. Yeah. Mr. Obvious had shown up. Good to see you, man. You said they were talking of tax and spare bedrooms. So these replacements also have no. Oh, yeah. You're talking about the third world people. Yeah. Have no personal, familiar, or familiar attachment either. That's right. So they'll turn against the native population very quickly. On top of that, because they're dependent on the government, they're going to do whatever the government tells them to do. They're going to follow orders. So they're going to go get the jibbity jab. They're going to take the chip. It doesn't matter because they need their benefits because they just came from a shithole and they don't have anything. So that's the main reason. I'm not trying to be mean. I'm just saying this is why they are doing that. This is that is openly stated by that Richard Kalergi guy that came up with the Kalergi plan in the first place. He's like, we want these docile, obedient, and dependent populations to replace the native populations of Europe. So not only that, but they also have no birthright to the protections of our several states. So that's a big aspect of it too, or even the birthright protections of what little bit of common law is left in Europe. You know, that I mean, that's the whole thing. They can never get rid of common law. They just remove your access to it by locking you in as a trustee of your own estate. So you have no lawful property rights to anything, and you can't enforce those rights at law. You only have equitable rights determined by contract and trust arrangement. You have to go to a court of equity where the judge is God to determine to try to enforce there, get some relief, and it's all just a rigged game. So that's why what I do here with the claim and the private express trust is we take the sand out of their sandbox. We don't play in the sandbox with them, their little UCC sandbox. No, we take the sand out of the sandbox and we kick the sandbox over and say, nope, no, we're not doing that. We're doing this in the real realm of actual living people, right? We're doing this at law. This is how we're doing this. So, all right. So we got, so I went over Sergeant Frog Dog's statement, and then it looks like Athlees Gertra says, I've never seen a reply from any government agency, even heard of it happening from anyone I know, even the banks. They just reply with boilerplate replies. And yeah, not when you send them the claim that I have. Absolutely not. Because it's a contract. If they ignore it, good. Ignore it then. Now you're the trustee, and I can enforce this contract against you in a court of arbitration. So, okay. Go ahead and ignore. That's what I was going to show you guys. Okay, very last thing I'm going to show you guys is proof that this works. Okay. Let's go here. Go to Colorado, Secretary of State. Right? Here we go. You'll end up with this evil bitch right there on the face of it, just absolutely corrupt and wretched as she is. You go to UCC Home. You go to search records. Yeah, I believe that's it. Search records. Yeah, they changed this. This is new, but all right. So search by debtor name. So individual, right? We'll do, his name's Wazzle Daniel A. You guys can do this on your own too. And search. Pops right up right here. Click on the record. Takes a couple moments, but here actually I'll open up the actual file in a new tab. Okay, so that popped up. I guess I can close the Heart of Blackstone too. And here, wait, why didn't it? It didn't open the actual document in a separate window. That's kind of annoying. All right, well, I guess we'll just look at it right here. So it tells you, we'll zoom in. So the judge, Daniel A. Wazzle, is a judge. He's a district court judge in Colorado. And let's get it centered there. And it tells you, as per Colorado Revised Statutes 1352-102, all goods, chattels, lands, tenements, and real estates of the four debtors are set forth as liened, right, or are brought forth as liened security under UCC 9-609. But he didn't use UCC to do this. So he did the claim that I showed you guys, right? That's in the Jurist Society folder. But his claim's different. Mine is, I revised it quite significantly because he has a lot of just fluff in there that I just didn't feel like was very, so I shaved it down to 31 pages and I just reworded a lot of the stuff because it was, in my opinion, there's a lot of typos. It wasn't written very well, but the bones are good. The bones are good of the contract, and it stands as a performance contract, so it worked, and I'm not knocking. So good on him. He did, and he was probably stressed and in a rush because these people were, hemming him up, and so he hurried up and got his claim on the record, and then boom, sent it to him. And anyways, so what had happened here is he took him through the common law procedure first. Okay. And he actually filed an at-law counterclaim against the judge, the prosecutor, the officer, and the clerk. That's the four debtors, if I remember correctly. and he filed an at-law counterclaim, which, remember, the court of common law, the superior court of record, is a superior court to these inferior courts. So being as both courts were dealing with the same matter, when he filed the at-law counterclaim for trespass on the case for the administration of his estate, his court automatically usurped the authority of the inferior court. Of course, the judge ignored it, but he kept a meticulous record and went through the whole process, the due process of the common law due process, and defaulted the judge because the judge refused to answer the show cause motions. And finally, he gave him 3 opportunities, and then he defaulted him. And then he took that default judgment down to the Colorado Secretary of State and filed it on with the Colorado Secretary of State, and they put a common law lien on all of his property. Then he took the performance contract that was in his claim and took it to an arbitration, which is private court, essentially existing outside the government. But Title IX of the USC makes it so that arbitration is binding. Like all courts have to respect the awards of courts of arbitration. They just have to. And one of the reasons is because it's one of the oldest forms of Roman civil law is arbitration. I mean, even calling a court case a case comes from that ancient system where basically both parties to a suit had to place money in a case, and then whoever won the court case got the case. And that's why it's called a case. Opening a case, winning a case, that's actually where the term case comes from. So and they lien, yeah, exactly. So all right, it says that it's lien security, right? And it says the collateral is related in part to real estate. Debtors owe $6,898,000 as per the unchallenged negotiable debt instrument, which is what the performance contract is. So we go down, it shows you what he filed. He's got the negotiable debt instrument, which is the claim. It also, in the claim, it forces them to give over power of attorney regarding any matters dealing with the estate. So you can sign for them in arbitration. Good standing arbitration. Boom. Certificate of good standing. Attorney General confirmation. Addendum. Judiciary courts for the state of Colorado. Contract. BC claim. Right? So, and boom. So this is the arbitration award. And this is the arbitrator's opinion. Right? But we're going to go down. I'm going to show you what the actual documents were. So these are the irrevocable, durable, special power of attorney. I have this also, right? And so basically when these people enter into tacit agreement to contract with you, you just print off one for each of the individuals involved with the administration of your estate and sign it for them. And look, you could, and there's his seal. It's right there. Right, so let's go down. Feel like it's not showing what I needed to show. There we go. There's another power of attorney. Boom, 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 boom. Boom, boom, boom. So he signed one for each one of them. This is the attorneys general's, this is Office of the Secretary of State, Innovative Holdings. Yeah, anyway, go down. Okay, yep, this is affidavit from the Attorney General. So that's the Attorney General approving it. And then we go down here to, there it is. That's what he filed. Look at that. Lawful claim of title, will, execution of will, declaration of status, appointment of trustees, appointment of trustees and standing orders for the same. So, and you go down here and I'll give you an example of a lot of the stuff a lot of the fluff that I took out of it. So, plus mine's formatted just, I don't know, so a little bit. I'm not knocking him though, I'm really not. So he's got his listed trustees. See, like this type of stuff is just unnecessary, where he goes, and all the respective subsidiaries, franchises, relations, divisions, departments, precincts, municipalities, princedoms, capitals, communities, agencies, and he goes on and on. He's got sisterhoods in here. He's got He's just got pretty much every name that anybody could ever be known by: adjusters, CEO, advisors, trust. And there's no need for all this. Benefactors, bookkeepers. There's just no need for. Look at this. It just goes on and on. And then there's another part in here, right here: trade codex. Look at this. So dispute, petition, tag, extension, remittance, entitlement, ticket, compensation, production, correction, storage, delivery, and he just goes on and on. You can sum these things up, right? You can sum these, which is what I did, and I just changed the wording significantly. So I mean, that is quite excessive in my opinion. Damn, now I just turned it all shaded. Liability, pawn. Look at this: curse, magic, witchcraft, drycraft, liblac, right? Conjuration, society, right? There's just so many things. Like, you don't have stuff like witchcraft, drycraft, spellcraft in your legal document and then expect to. But I mean, the judge didn't take him seriously, and now the judge can never do anything with his property without paying this guy, Brett Andrew Nelson. So good on him. He did his thing. But that's my point. And see, even beyond this, where the judge was taking him for personal liability and attempting to administer his estate, all of the property that we would use to interact with the public, quote unquote, or that would otherwise be used to create an attachment, like anything connected to your social security number, that being land, automobile, boats, just stuff like that, where they can create attachments. We're putting all that property in a private express trust, and the trust instrument's going to ensure that it cannot be used in commerce ever. So it cannot be subject to the commercial regulations, i.e. the motor vehicle code. And so that's the added layer of protection that we do in the Jurist Society, that I don't know if he and his people did that or not. But anyway, just a little tidbit, show you guys that I'm not just talking shit. It actually works. So yeah, that's it. All right, let's look and see what you guys got. Yes, tacit acquiescence. That's right. And then you lien them. Exactly. Let me. So it says, consider reviewing the work of Jack and Margie Flynn. I have no affiliation, personal or otherwise. I think you might appreciate the relevance. Be well, everyone. Abide in faith, never in fear. The only thing I'm concerned about, and I will check them out, the only thing I ever get concerned about, and I'm not saying this is the case with these people, but anybody who considers themselves like constitutionalists or constitutional scholars and stuff, that tells me that they haven't realized that the Constitution is actually a document of enslavement. That's why they replaced the Articles of Confederation with it. They were worried about the common people having power. So yeah, that's what we're stuck with, and we have to use, to a certain degree now, because it's a far cry to go, well, this was unlawful for you guys. But long story short, Thomas Jefferson, when he came back and he found out that the Constitution had been ratified and placed the Articles of Confederation, he was pissed, and he told everybody, he said, the germ of dissolution is seated within this infernal document. It will allow the judicial branch of government to work like gravity by night and by day to usurp the sovereignty of the states. And that's exactly what happened. And it was by design. There's so many loopholes and backdoors in the Constitution that when Jefferson read it, he turned around and told everybody, you better have a Bill of Rights amended to this Constitution immediately, or you'll have fought that war for nothing. And so Thomas Jefferson, Patrick Henry, and Thomas Paine went around and rallied the people to have a Bill of Rights amended to it. And it was the outcry of the people that forced it to happen. That's been the greatest stumbling block of the New World Order ever since. But this is evidenced by the fact that the Constitution was ratified in 1787. The Bill of Rights was amended to it in 1789. Why wasn't it included in the first place? But there's a bunch of other stuff. Read Eliot's Debates, which is James Madison's diary, like basically his diary concerning the Constitutional Convention. And he basically says, well, when the majority unite in a common interest, the interests of the minorities are in peril. And he's talking about the wealthy people. If the common people have power, and their interest in not being property and not being subjugated by aristocracy, right, will basically be a threat to our aristocracy. That's James Madison was a piece of shit. So, with that being said, but I will definitely check them out. But I will check them out because, yeah, definitely, and especially if they're elderly people, I love the wisdom of our elders for sure. They lived in a time that we can only imagine. So it says, Sergeant Frog Dog says, I carry a document from my trust in the automobile with just enough information to let them know it's in a trust, protected and under contract, not used in commerce. And of course, their liability. That's exactly right. And that's the whole thing, is you don't want to disclose the entire, Sergeant Frog Dog's absolutely right. You don't want to disclose the entire details of the trust, nor are you under any obligation to, right? Because in fact, you can add an NDA agreement to your trust if you want, to where the trustees are not allowed to disclose the nature or the terms of the trust if you want. And that means for them to compel you to present information about the trust is literally coercion, and it's forcing you to violate your obligation to a contract. But even without that, the good thing, or what you do is like Frog Dog says, is you take the first page and the last signature page of the trust, and you keep that with you and leave all the rest of it out, right? And just to show them, hey, this property's in a trust. This is the trust right here. And the bill of sale that shows that the trust bought the automobile for lawful consideration over $20, which puts it at common law, not Federal Reserve notes, actual silver or gold, low grade gold though, right? One that actually can be used for trade at common law, because higher collector's grade gold tends to not have the fair market valuable in common trade as it would to a collector. So it's not a good idea to use, collector grade gold. You just want low grade gold. But either way, it's lawful consideration per Article 1, Section 10. And that's absolutely right, Sergeant Frog Dog. That's exactly what you do. And it lets them know. And they're automatically liable to have their asses sued off. Not only in our instance with the claim and everything, not only can you sue them for the claim, but you can sue them for the distraining the trust of its property for a debt that the trust doesn't owe, right? And trying to compel the trustee to violate the terms of the trust. It's all bad for them, all bad, all the way around. But anyways, other than that, thank you guys for joining me tonight. As always, I appreciate you guys showing up, being interested to learn this heady and sometimes grueling and boring stuff that is so very important for everybody to know. And if everybody did know it and continued to teach their children, we would have never ended up in this situation to begin with. And yes, I agree. Aflees, Aflees says they're just so arrogant in their ways. I couldn't agree with you more. DeWitt says, you make important distinctions, Ryan. No doubt you'll make sound independent conclusions should you decide to initiate communications with them. Yeah, absolutely. No, I'm definitely going to check them out. In fact, let me put in their names in my search bar right now, just so I don't be like, damn it, what was their names again? You know what I mean? Don't want to do that. So, Jack and Margie Flynn. Okay, so we'll do that. I'm just going to put it in the search bar real quick. Margie. Whoops, yeah, I suppose that would be Citizens of the American Constitution.net. Okay. I'll have to go on my phone, but yeah, because this stupid AI run Microsoft Edge. I can't stand Microsoft. So yeah, Sergeant Frog Dog says, knowledge is life. When you're finished learning, you finish living. Amen to that, man. You're absolutely right. So, well, thank you very much, guys, for being here. Thank you for the suggestion. Do it. And I will see you guys, if not tomorrow, then the following evening, we'll do another stream. So you guys have an excellent evening / morning, whatever time it is for you. And I'll see you later.